For the past several weeks, several high-profile trials have gripped the nation, with one striking similarity: defendants willing to take the stand, including Kenosha shooter Karl Rittenhouse, who was ultimately found not guilty on all charges, and in Georgia, Travis McMichael, who was found guilty on all counts for the murder of Ahmaud Arbery. In Charlottesville, several white nationalists took the stand as well and were found liable for millions in damages for that deadly 2017 Unite the Right rally. And Theranos founder Elizabeth Holmes, who spent 3 days on the stand, including one where she testified for 6 hours. She's set to actually continue that testimony on Monday. So joining me now to talk about this is Bob Bianchi. He's the former head prosecutor in Morris County, New Jersey, and the host of the Law and Crime Network. Bob, thank you so much for being with me this morning. But I want to get your take on whether or not this is something that you are used to seeing, or how rare is it to see the defendant take the stand, even though, of course, all of these cases that we just talked about have critical differences.
They do have critical differences. And as a former prosecutor, when I was waiting for a defendant to get on the stand, I loved it. I was like a lion in a cage waiting to cross-examine that witness. I don't think it's a trend. It depends on the facts of the case. It depends on the client. In some of these cases, there was a reason to do it. And in my mind, especially with Holmes, I think that there may be even a little bit of ego in it, where they want to get their story out. Nevertheless, they hurt themselves on the stand. When you look at the Rittenhouse case and you look at the Arbery case, there's really important reasons why those defendants took the stand. In Arbery, he had to take the stand to assert his affirmative defense. The jury needs to understand why he felt it was reasonable to use lethal force. In the Rittenhouse case, for example, I think that was a tactical mistake, although it worked out well for him, because his self-defense claim came through the other witnesses that testified on behalf of the state. But in the end analysis, as lawyers, we tell a client whether they should take the stand or not take the stand, and it's up to them ultimately as to what the decision is.
So, but you see this, it was effective for Karl Rittenhouse in the end, obviously, after that testimony, talking about what he personally went through during that period. But then obviously with the McMichaels, you saw Travis McMichael take the stand. And of course, we saw how that verdict was read on Wednesday. Of course, guilty, guilty, guilty for all three of those men. And obviously, Travis McMichael was the only one to take it. So how do you know if it's going to be an effective tactic if you're then a defense attorney?
In Rittenhouse, I would imagine his lawyer told him that I don't think you should take the stand, because 4 witnesses for the state, including one of the victims, Grosskreutz, testified very favorably towards the self-defense claim. So there was no need for Rittenhouse to get on the stand. But after the interviews were done with the lawyer post-verdict of not guilty, he indicated Rittenhouse always wanted to get on the stand to tell his story. So that was a little dangerous there. For McMichaels, Travis McMichaels, he had to get on the stand. That video was so bad, there was not good explanation. And so he needed to contextualize what was happening during that incident to the jury. And so he must take the stand. Ultimately, obviously, the jury didn't buy that. But the evidence against McMichael was very, very strong. And the evidence, respectfully, and I know there's a lot of controversy about this, doing my show, I was listening to the state's witnesses as a former homicide prosecutor. This was the prosecution's witnesses. And I was asking my producer, is this a defense witness or is it a prosecutor's witness? Because so many of those witnesses dispelled the narrative that Rittenhouse was the aggressor, that Rittenhouse went and brought the weapon into Kenosha, which is not accurate, and that Rittenhouse was the one that was going after people as opposed to what we saw on the video. So Rittenhouse took more of a risk because there was evidence to show that already with the witnesses in the video. With McMichael, he had to take the stand because his case was going down in flames.
Bob Bianchi, thank you for joining us this morning and sharing those insights.
Thank you.